A very important lawsuit is currently pending in the United States courts. It's called Texas versus Beccera. It threatens essential protections for individuals with disabilities under Section 504 of the Rehabilitation Act of 1973. 17 states have challenged the federal government's updated rules. Section 504 requires any program or activity that receives federal funding to not discriminate against disabled individuals based on their disability. Because all states receive some form of federal funding, the law covers the entire nation. It was among the first laws designed to protect the rights of individuals with disabilities, preceding the Americans with Disabilities Act of 1990. These regulations require schools to provide appropriate support to students with disabilities, ensure hospitals have sign language interpreters, mandate captioning for videos, and require accessibility medical equipment for wheelchair users. In May 2024, the Biden administration's Department of Health and Human Services updated Section 504, called the Final Ruling, after getting input from disability advocates nationwide. One of the updates addressed a contentious issue: gender dysphoria, which occurs when a person experiences significant distress due to a mismatch between the gender they were assigned at birth and the gender they identify with. The American Psychiatric Association states that gender dysphoria can lead to psychological distress, including feelings of anxiety, depression, and social isolation, which may affect one or more of their daily life functions. The Biden HHS stated in a preamble of its final rule that an individual with gender dysphoria may have a disability under Section 504. While the rule does not assert that gender dysphoria is now a disability, it supports the notion that individuals may be disabled and require protection. But here's the kicker. The 17 states that filed the lawsuit, all of which are red states, seem to have exaggerated HHS's statement by asserting that Biden added gender dysphoria to the definition of disability under Section 504. From what I've read, the Biden administration shared its support in the preamble of the final rule, which is not considered part of the regulations and can be rejected by new administrations. The 17 states said in the lawsuit, because gender dysphoria is purely psychological and not physical and cannot be confirmed or falsified by any physical test, it is not and cannot be a disability under Section 504. However, their lawsuit does not require the courts to dismiss this specific update on gender dysphoria. Instead, it seeks the broad declaration that Section 504 is unconstitutional, thus invalidating the entire law. On February 25th, these states and the federal government, now under Trump's administration, will submit legal briefs to the United States District Court Judge Wesley Hendricks, who was appointed by President Obama. What is your thoughts on this? Should the entire section of 504 be thrown out? Do you agree with the federal court ruling that gender dysphoria may constitute disability under Section 504? Put your thoughts in the chat.